The City of Santa Barbara. Lori, would you call the roll, please?
Chair Grant House.
Here.
Frank Hotchkiss.
Here.
Randy Rouse.
Here.
Very good. We have an item that's coming back to us on the committee. It was here back in October, is that right? The last time it was here? December. Okay. And Lori, you want to introduce our staff and get us started?
The item before you today is the hedge ordinance suspension, and Renee Brooke will be presenting.
Good afternoon, members of the committee. Thank you. We are back before you today to discuss potential temporary suspension of certain hedge regulations. As a way of a little bit of background, in the summer of 2008, we heard from many neighbors, and City Council heard also, concerns with a number of complaints regarding overheight hedges, and also just general concern with what they felt was uneven enforcement throughout the community, since we do almost primarily enforce on a complaint basis. So as a result of that community discord, in November 2008, the council expressed interest in amending the ordinance relating to hedge heights. Council at that time recognized that it would take a lot of community outreach and input in order to actually accomplish that task. So at that time, on November 25th, Council adopted Ordinance 5470, which temporarily suspended for 2 years certain hedge regulations in order to give staff the time to do the outreach and consider a potential amendment to those hedge regulations for Council's consideration. The 2 years have passed, and staff has not had the time and resources necessary to conduct that outreach and come back to you with a proposed amendment. And so we're here before you today, and we were also here on December 14th before the committee to consider some different options as we move forward in potentially having another suspension of those certain hedge regulations while we again, try to have that community dialogue for a permanent amendment in the future. Also, at that time, I do want to point out that on November 25th, 2008, when we came to the council to ask for a temporary suspension of certain hedge regulations, it was brought up at that public hearing that there be an exception for the bamboo plant, and that it tends to grow relatively quickly, and so that was added as an exception to the suspension ordinance, and I'll show that language to you in a moment. So I'll quickly go through the sections of the hedge ordinance that were affected by this suspension. There's 7 sections of the hedge ordinance, and only 2 were really affected by that suspension, and that is subsection A here, which restricts fences, screens, and walls and hedges to 8 feet when they're in a required setback. And also B1, which requires hedges to be no more than 3.5 feet within 10 feet of a front lot line. So for the past 2 years, we've not been enforcing those regulations of the hedge ordinance. All others have remained intact, and those are strict, primarily those related to safety, either traffic safety, pedestrian safety. Those hedges next to driveway have continued to be enforced, as well as subsection C, which relates to hedges, screens, and walls near street corners, which are in effect for vehicular safety and being able to see pedestrians. And I do want to point out that since the suspension went into effect in November 2008, it's been our administrative practice when we apply this section of the ordinance that we do consult with transportation operations staff and get their opinion as to really how much of this hedge needs to be trimmed in order to meet the intent of this requirement. So we do try to work on a case-by-case basis in those situations that make sense for visibility issues. The remainder of the sections of the hedge ordinance were not affected by the suspension, so I won't get into those today. So our staff recommendation to you in going forward with another potential suspension of those same hedge regulations is, for the most part, a similar extension that was in place for the last 2 years with one change, and that is here in the second bullet. Whereas the previous suspension applied to all hedges, whether it be enforcement or someone coming forward seeking a development application or a building permit, we didn't apply those hedge regulations to any of those situations. What we propose we do in the future is that if someone is seeking approval for new development that requires approval by the staff hearing officer or the planning commission, that at that time we enact those hedge regulations that had been suspended otherwise. And the reason for that, why we're picking that as the trigger or the criteria threshold for when these hedge regulations would be applied, is that typically if a development is requiring staff hearing officer review or planning commission review, it's significant enough that we're going to want to consider all aspects of the property in light of the development. There's a site visit done by staff and the decision maker, and we do a complete zoning plan check. So we feel like we'd have a complete picture of the entire property and could weigh through the discretionary action of these decision makers the benefits or potential concerns with that development and how it might relate to the hedges on the property if that applies. And then we would also recommend that we continue the enforcement of bamboo hedges as was in the previous suspension ordinance language.
You mean the safety portions?
Well, yes, that too is correct in that in the first bullet there, by extending the suspension of only subsection A and B1, all those sections related to safety impacts would still be enforced. So those hedges next to driveways and street corners. So that would not change.
Okay, so if I may, so in a sense in the new development we're sort of starting them out at ground zero, and then once they conform to whatever the new regulations are, then they go into the existing category and become exempted from the future from the ordinances. Is that correct or not?
I'm not sure I understand the question.
Okay, so let's say we start off, you got to have 3 feet in front and 8 feet side and back. Okay, you passed that, good, you've done. All right, you're now in the pool. 2 years down the line in the backyard, they're 10 feet. In the front yard, they're 3.5 feet or whatever. But that doesn't trigger any enforcement unless there's a complaint against them. Is that correct?
Correct. If under this suspension ordinance,
Right.
we're assuming we're not enforcing on those interior hedges that have to be limited to 8 feet. Correct.
Right, that's what I mean. We start them at ground zero where everybody was supposedly at one time, and then they go into the pool after that.
Sure.
Okay, thank you.
Right. Okay, so that was staff's recommendation. Another option that's presented in the staff report is to simply just extend the same suspension ordinance language that we had in place for the last 2 years, in that we would suspend both enforcement of those two sections and would not apply it to all new development in the city. So the way that that would look specifically in the ordinance that you may forward to council today, if you decide to do so, is the previous ordinance was attached as an attachment to your staff report, so you have the language of the last ordinance. Section 1 of that ordinance would not change. This simply just lays out the two sections of the ordinance that are suspended with this proposed ordinance. Section 2 is not shown there because it wouldn't change as well, and that just refers to any hedges that are out of compliance with the Uniform Fire Code would have to be abated, so we're not proposing any change to that. Section 3 would be a new section, and essentially what this is saying is that although we're saying that we are suspending application of these certain sections of the hedge ordinance, Section 3 basically explains where we would not do that, where we would not suspend that, and we would apply it to those projects that have to go to the staff hearing officer or planning commission. So that's the technical language describing what I explained earlier. Section 4 just explains that this proposed ordinance would be in effect for a period of 3 years this time. And Section 5 is new, and this was based on our discussion on December 14th when we were before the committee. You'd asked for some clarification as to how this ordinance would or would not affect the underlying section of this municipal code, and that if private parties wanted to refer to it in negotiations or court cases, that it would not delete or repeal those zoning standards, and also that this temporary suspension would not have any effect on the city's view dispute resolution. So Section 5 here is coming straight from our discussion the last time we were before the committee.
So if they were attempting to seek civil remedies, they could refer to the ordinance as part of their discussion. And if it were a view dispute, this could also be then referenced. Even though we're not enforcing it, they could use that as part of their conversation.
Mr. Chair, that is correct, yes.
Yeah. Mr. Rouse, you have a question?
Yeah, thank you, Mr. Chair. Isn't it true that virtually all residential zoning enforcement, other than health and safety, are pretty much complaint-driven?
Mr. Chair, Committee Member Rouse, that is correct.
Okay, and more for your presentation?
Just to quickly summarize here, our recommendation is that we suspend enforcement of 2887-170A and B1 related to hedges for enforcement and most new development. We would only require those seeking approval for development from the staff hearing officer or the planning commission to comply with all applicable standards of the hedge ordinance. We recommend that bamboo continue to be an exception to the suspension, and that means that the height regulations would apply to all bamboo hedges. And this time we recommend that the temporary suspension ordinance be in effect for 3 years to ensure that we have the time to have that community outreach and come back to council with the recommendation to amend this ordinance. And that concludes my report.
Thanks, Ms. Brooke. Before we take questions, do we have speaker slips today? Are there any questions for clarification with staff at this point? Okay. Okay. Okay, we have 4 speaker slips today. Nick Bartolini. Okay, we have 5 altogether.
Actually, Mr. House, I didn't plan to make a presentation. I submitted in writing a proposal yesterday to save the committee listening to me waffle on here, but it's formalized. The attorney has a copy. The young lady has a copy, which is, I believe, goes in that direction. But I think the one minor, I think it's significant deviation is then rather than consume the staff's, who's overburdened, the council and everyone else time, that when a proposal for a new development comes in that requires a building permit and such, that with regard to hedges and all the rest of it, that I think it should be based on a neighborhood basis. Get the agreement of the neighbors in writing, attach them to the submission, and that would save the staff and everyone else an awful lot of work. And I say that because it seems to work. I've lived in the Upper East twice now, and it's worked very well. I have just recently gone through a remodel. Neighbors in complete agreement. I am not an official representative of the Upper East Association, but I've sort of backed into representing a number of my neighbors. And I've got a whole sheaf of emails in there as such. And they tend to view, Santa Barbara is an eclectic place, and we all love it the way it is. The Upper East particularly is a place with lots of walls, high hedges. That's why I live here as such. And you take an example I pointed out last time. Between Constance and Mission, I think there's about 7 or 8 properties that don't have fence or hedges or walls out front. Mine was one of them. What I have done, as I conceded last time, I conform to my 2 neighbors, both of whom are grandfathered.
I see.
With hedges, and that you find that's why I say I think it's different in different areas. They're all grandfathered. The technicalities of the law, they'd all be in violation.
Okay, got it.
And so the point,
All right.
my guiding intent is a little book that I held up last time, which I think is very, very helpful, is to participate and conform to that neighborhood's ambiance, character.
All right.
That's exactly what I've done. Could be examined.
Great.
And that's the heart of what I'm
Staff,
saying.
do you have a copy of his letter that he sent?
Yes, she does.
Okay, just want to make sure.
And
you
I
have that.
think the other point, well, it's not really my personal business. I think it would unload an awful lot of staff and other people's workload
Okay,
basically in this and devote to something more important.
thank you very much. Thank you. Kelm DeForest will be followed by Mia Shalhoub. And we have 2 minutes on the clock, so you can speak to us, and if you would, in that time.
The basic, good afternoon.
Hello, Mr. DeForest.
The basic problem with hedges is that they grow. And this needs to be addressed in any ordinance. It is that your 3-foot hedge in front of your property that conforms when you planted it is going to be 4 feet, 5 feet, 6 feet, depending on what kind of material, unless it's constantly trimmed. And so I would like to explain, would there be any enforcement of these sprouting hedges that some, except by neighbor interaction, that would that you could get or force a neighbor to trim a hedge that is growing way out of proportion to both aesthetically and in violation of the ordinance. Also, I would like to ask, why 3 years? Can't this problem be, shouldn't that be modified? That it seems a shame to wait 3 years to solve the hedge problem. Also, I think another plant that dangerously, or not dangerously, but can obscure everything besides bamboo is pittosporum, and maybe pittosporum ought to be included with bamboo as a hedge material.
Thank you very much. Thank you. Mia Shalhoub, followed by David Gottenberger. Hello.
Hi. I realize I submitted my writings to you without my name on it, so I apologize for that. And I'm here to speak about the problem of the bamboo, and I see that it's already part of what you guys are supporting to be able to cut the bamboo, but I live on a property that is hedged by giant timber bamboo, so I'm just here to speak to the reasons why I believe that it should be cut. And the pictures that I submitted will really show that it can grow up to 50 feet tall. It's about 35 feet on our border between our house and our neighbor's house, and I believe that we have the right to have sun in our gardens. We have the right to have solar power, and all of our south-facing sun is being blocked by this gigantic hedge. It's definitely an eyesore in a small neighborhood such as the Marine Terrace on the mesa where I live. And in this case, the bamboo, even though we're not really speaking to how invasive it can be, there are bamboos growing on our side and pushing the fence over now. So it also drops a tremendous amount of debris on our roof and side yard. And this summer, the debris from that bamboo created a leak. And I have shown pictures of all of those things. So just want to say thank you for your consideration and for having the giant timber bamboo, especially the giant timber bamboo cut. And eventually, hopefully, there'll be a law in place that this can't be used as a hedge because it's extremely invasive and it's considered a invasive weed, in fact. So it's also a potential fire hazard. So I just wanted to speak to all those points, and thank you for your time today.
Okay, thank you. Stick around. I think we might have a question or two. Mr. Rouse, did you have a question for her? Okay, Mr. Hotchkiss?
Yeah, I do have a question. Can you not, or have you not, filed a complaint regarding that?
Actually, I have several emails that I've submitted with my testimony today, and it's been...
No, complaint against the hedge.
Yeah, I've been
And-
complaining
and
with the city, but since this...
The city's done anything on that?
No, they haven't. In fact, the person in question that we've made the complaint against used to work for the city, and she's using that knowledge to
Well, that's
block...
okay. That's conjecture. Staff, can I ask you a question?
Okay, thank you very much.
Could that complaint be followed up under the existing rules?
Mr. Chair, Committee Member Hotchkiss, I believe that complaint was originally filed before the suspension ordinance went into effect.
Okay.
So it was enforced under the rules on the books.
But it's still there.
Right. We have been seeking abatement of that violation for quite a while.
They just refused to comply.
Correct.
Okay, thank you.
Okay, very good. David Gottenberger?
Brokenberger.
I'm so sorry. Grokenberger, followed by Jim Webb. All right.
Thank you. I'm an attorney in town. I spoke at the last meeting with regards to a clarification that I thought might be appropriate that was set forth in Section 5 of the proposed ordinance language. I wanted to say to staff, thank you. That clarifies the concern I had, and City Council, I know, our City Attorney worked on that. If there's need to go back over the reasons why that distinction is important, I'm here to answer questions. Other than that, I think the ordinance is ready.
Okay, thank you very much, sir. Thank you. And then Mr. Webb?
Hi, council members. I'm a little concerned about the equal protection implications of excluding one species of plant. It doesn't seem fair, and I don't understand the rationale. There doesn't seem to be a rationale for excluding one species of plant. Clumping bamboo has been allowed by the Community Development Department. But be that as it may, it doesn't. I don't see the rationale in excluding one species of plant. And I was wondering if that could be addressed.
Okay, well, we can have staff take another attempt at explaining why the recommendation is such. Is there anything else?
We do have a clumping bamboo hedge, and we planted it for privacy because no mitigation of privacy was allowed to us, and it doesn't seem fair that why would a view trump privacy? And that's what I'd like to say.
Okay, why don't you stick around? Do we have a question for the gentleman? Mr. Hotchkiss?
I guess I'm looking at 217 Los Alamos Avenue. Is that you?
Yes.
Okay. Got a two-story house there. Top of it's probably 30 feet high, right? Mm-hmm. Okay. And you got a privacy issue with what appears to be a 40 or 45-foot bamboo hedge. What's the extra 15 feet? How does that help your privacy?
It does not, but the hedge has just grown, and we have not cut it because we're currently in litigation over.
So would
the
you be
hedge.
happy to cut that?
Well, we're not. I can't really say at this time because I'm not really
Well,
sure.
maybe we could get you out of litigation here. Would you perhaps be happy to trim it?
Yes.
Okay. And quick, your neighbor makes a point that she probably can't grow roses in the garden anymore because you're got a lot of sun blockage there. Would you agree with that?
Well,
It's
the sun is
possible.
also blocked by
What's that?
our sun is also blocked by the addition.
And so maybe, the best thing is when neighbors finally decide to cooperate. Would you agree?
Mm-hmm.
Okay. Thank you.
Okay, we have one more speaker slip here. Are there any other questions for Mr. Webb? Yes, Mr. Rouse. I'm sorry, Mr. Webb, if you'll come back for a minute.
Thank you, Mr. Chair.
Thank you.
Mr. Webb, you mentioned that you did not receive a mitigation of privacy. Could you explain that, please?
We asked for, during the development of the project, we asked for some mitigation, but we were not allowed the city would not listen to our requests for some sort of mitigation on their side of the property for privacy.
Would you clarify? Sorry. Would you clarify what it is you were asking the city to approve?
Some sort of landscaping, or and also the windows of the actual addition are huge, and they look right into our backyard. So we lost all our privacy, and the windows are also, the sun reflects off them right into our house, and it's pretty ominous.
So you were asking for basically what would be a variance in the standing zoning codes at that time?
No, just for mitigation, some sort of mitigation, which is common practice for our privacy.
I can't answer to that.
Okay, good. I think, Mr. Rouse, I think the neighboring house, they had made an addition, and that started this
Right.
issue. Okay, thank you very much.
Thanks.
And then L. Gemberling, is that Linda? Will be our last speaker on this item today. Mr. Vincent, would you help us? What's the status of the city with regards to this issue? Are we involved at all directly, or is this between the parties themselves?
No, Mr. Chair. As I understand it, this is an active code enforcement case, and there is pending litigation with the Gemberlings about their hedge, seeking compliance with the hedge height ordinance.
Okay.
So this is it's still pending.
Okay, thank you very much. Ms. Gemberling? Yes.
Let's see. I'd like to add, there's no background information or justification indicating that bamboo is a fire hazard. In fact, if you read literature on it, it is the opposite. The justification that bamboo goes crazy in 2 years is just not true. There's bamboo all over the mesa, and it does provide us with privacy. There's a deck of the neighbors that looks directly, that has no bamboo in front of it, and they have their own bamboo growing in front of it, overheight bamboo. And if they cut that, they would have a nice view. Also, there's bamboo on the back perimeter of the complainant's property, and that has not been enforced against whatsoever. It's growing into electrical wires. In fact, Southern California Edison was out there to cut that bamboo, and they did not cut it for some reason. And I asked them about our bamboo, and they said it was fine. And finally, I think Mr. White made a statement about, I know he's not on the committee anymore, but about, I don't care if the view is from a second-story bathroom window, which is exactly where the individuals next door get a great deal of pleasure looking out of and to our property. So we need it for privacy desperately. This whole enforcement case has been this piecemeal. First they made us cut our front strip, then they made us cut a hedge on the side, then they gave us a wrong house. I mean, we've been cutting everything at our house. And then finally, I guess because of Ms. Shalhoub's focus and somewhat obsession with our bamboo, they just, I don't know,
Okay. I think we're out of time.
I think it's view versus privacy.
All right.
And I
Thank
think
you.
that the person with a monolithic home has less property damage done to them than the person with a hedge who is hoping to sell their house to get away from the unpleasant neighbors they live next door to. And then that hedge could be cut.
All right.
But
Thank you very much, Ms. Gamberlin.
Yeah,
thank you. Thank you very much. A quick question for our staff. Mr. Vincent, any action by the City Council on the recommendation today, would that have an impact at all on the litigation that's I mean, would that work backwards, or how would that have any effect, if it would at all? Oh, good. There we are. Yes, sir.
In a word,
Mr. Wiley.
no.
Thank you. That's what I'm asking.
The charter charges the city attorney with enforcing municipal code, and that's what we're going to do here. And I have to tell you, having participated very in detail in the city's view dispute, the drafting of the view dispute ordinance, and in having council chambers full of people concerned about legitimate concerns about what had been their ability to look out a window and to see something. We've got real neighborhood concerns in this community over things like views and privacy, and we have a very delicate balance, I think in large part because of that view dispute ordinance, which I think you probably know is a private right of action. The city does not really we created this process for mediation and even arbitration and even litigation. Mr. Grokenberg is very familiar with it, to resolve view disputes. But I'm only mentioning this here because I think we need to be careful about what we do with hedges, or they're going to implicate this very delicate balance of privacy and views. And clearly, they're both legitimate concerns, and in fact, it's important to recognize that cities traditionally are concerned about protecting people's privacies. That's why we have privacy. That's why we have setbacks. That's why we have design review boards that allow public input about second-story additions and where windows go. And we have this whole appeal process to deal with issues like that. But anyway, to answer your question, no, nothing that happens today will impact that Superior Court litigation, which has been ongoing. It has not been easy to deal with, but we're set for trial finally, I think, in a few months on that case.
Okay, thank you. I think you're pointing to the reason that the staff is requesting or recommending some kind of suspension here for us to have the time to do the work you're talking about. All right, thank you. So it's to our committee unless staff has something else. Okay, Mr. Hotchkiss?
I guess I want to ask City Attorney or Scott, if the disagreeing parties today said, okay, we'll cut the hedge to 15 feet, could we get out of this whole thing? Could they get out of it and everybody go on their way?
Mr. Wiley?
Well, I guess the answer is probably no. It's not that simple, because we enforce municipal code. Right now, the municipal code says that you can't have a side yard hedge over 8 feet. 8 feet is where we define your protecting your privacy. Could you tell us it should be 10 feet? Yes, but you should do that citywide and in an ordinance. And we can't really have code enforcement, which is supposed to be pretty objective, albeit generated on a complaint basis. Once it gets to us, we try to be uniform and we try to be fair with everyone. We can't have the neighbors saying, all right, well, we're going to ignore the municipal code and cut a deal. Because, for one thing, I think it's going to cause more people to violate the municipal code in the hopes that they can cut a compromise with their neighbors. And, you know, it reminds me, in something like this, this hedge ordinance has been on the books for 50 years. 90%, maybe even 95% of code compliance is voluntary. The average person is told this is what the city code requires, and they do it. They simply do it. You and I and most of the people in this room, we do it because it's the law. So I think my point is we shouldn't overreact to a few code enforcement cases and the difficulty of some neighbor filing a lot of complaints, because I would say 90 to 95% of the people obey the law because it is the law, and because the council has made this delicate balance for things like this.
Thank you very much. I do have more things about that.
Why don't you go ahead, Mr. Hotchkiss, and then Mr. Rouse after that. Excuse me. No, thank you very much, but we're done with the public comment for right now.
The way just to go back to review where we stand right now. If somebody's got a hedge that for a long time is fine and then the neighbor decides to complain, we do investigate that?
Mr. Chair, Committee Member Hotchkiss, that's correct. If a complaint is filed with zoning enforcement staff, we will go and investigate and see if there is a violation that we confirm on the property.
Okay. Could you clarify for me if we have rules that sort of work, sort of in a neighborhood sense, everybody's trying to get along, and until it becomes egregious, nobody says anything. If we have bamboo there. Is the real problem that instead of growing to 8 feet in 4 years, it grows to 20 feet in 4 years, that it's just out of control?
Well, excuse me, the concern that was expressed the last time this issue was before council in 2008 was the fast-growing nature of bamboo, and that if we suspended for 2 years enforcement of all hedges, including bamboo, that was one species that could grow particularly quickly
I see.
in that period and quickly become out of compliance.
I see. Okay. I understand that. At present, if somebody lodges a complaint, is their property also inspected?
It's not typical for our administrative practices to do that. No.
Right. Might be a good idea. Let's think about that. Thank you.
Okay. Mr. Rouse?
Thank you, Mr. Chair. A question for the city attorney. In the proposed, I don't know if it's in the proposed ordinance language, but in the proposed recommendation about bamboo per se, and I agree. I think bamboo can be a particularly destructive force around a home. Is that the proper thing to do, to call out the one species, or should we have some language that talks about a particularly fast-growing species? I'm not a horticulturist, but I don't know if calling out one specific species, and there's a bunch of different types of bamboo. Is there a slippery slope there that I'm missing? Or
Mr. Vincent?
Mr. Chair, members of the committee, we certainly are aware of bamboo as a fast-growing species. The 2 or 3 hearings regarding the suspension ordinance that I've sat in on and the past testimony did not include other species. I just don't know if we have the information supporting another laundry list of species. We certainly do have the knowledge of bamboo and its ability not only to grow quickly, but also to grow to a level that where not only whether it happens quickly or not, it grows to a height that most other species do not grow to, as is evidenced by those photographs that you were given.
I guess I was just trying to help in case there were other species out there that we could be facing in the future, or some other kind of hybrid that wasn't called bamboo that had a similar growth rate. I didn't know if there was a better legal way to phrase that would kind of prevent us revisiting this on this exact same topic. That's all I had to ask.
Okay, well, Mr. Rouse and Mr. Hodgkins, I'll just weigh in real quickly. I tend to concur with staff's recommendation. I mean, we could pick any particular hedge in town or that's had some contention around it, or a particular species. Pittosporum is a good example that's sort of similar in a way because it just bushes out and goes crazy, it seems. But I would tend to think that we would just suspend for not just carve out bamboo at this point until we can finally get a chance to do the work that staff is asking us to do within the next 3 years. And so that's the only piece of the staff recommendation. I don't know that it's all that necessary. We have one really big deal issue that we saw pictures of, but that's actually in litigation right now and being worked out. And we don't have any other big serious complaints about that, even that particular species. So for me, the suspension would be just fine. I don't think it would affect that situation in any case, but without that calling bamboo out altogether. So I tend to side with staff's recommendation with the exception of the pulling bamboo out. And I'd like to hear your comments as to what you want us to do going forward. Because today we're here to make a recommendation to the City Council. Yes, Mr. Hodgkins.
Thank you, Mr. Chair. Regarding the trigger for enforcement, if you put a water heater in, is that going to trigger enforcement? Because you are required to get a building permit for that.
Mr. Chair, Committee Member Hotchkiss, under the staff's recommendation, it would not enact the hedge requirements that we're proposing to suspend with this ordinance. It would need to be a type of development that requires a staff hearing officer approval or planning commission approval.
So explain to the public what that means, if you would.
Sure. So that level of discretionary review, most often the staff hearing officer reviews applications for modifications. So those are situations where someone is asking to modify the zoning ordinance requirements to allow for an encroachment into the setback or a window to get larger in the setback, some type of deviation from the code requirements. They're requesting a modification approval for that. That's the large majority of applications the staff hearing officer sees.
Not a kitchen or a bathroom remodel.
Not a remodel inside unless they're also bumping out into the setback as part of that. And
So if you change the
requesting
footprint
relief.
of the house a little bit, is that what tends to be a kind of trigger, even if it's minor or not?
Typically, a change in the footprint to the house, or a slight increase in height in the setback, or doing a second-story addition in
If
the
it's
setback.
not in the setback, no problem?
Correct.
Okay.
And then the Planning Commission sees the larger projects, the subdivisions and conditional use permits, and the typically more complicated, larger development projects.
Okay. This gentleman's suggestion about neighborhood agreement, would there be some way to incorporate that? Did you understand what he was saying?
I do. I think I understand what he's suggesting, and I could be corrected if I'm wrong, in that if someone were seeking approval from the staff hearing officer or planning commission and had letters of support from their neighbors to allow them to keep an overheight hedge, that could be considered as part of the decision maker's decision. I think that could be considered just like any other letters of support or opposition that the planning commission or staff hearing officer receive. They could consider that as part of their decision.
So that could overcome the trigger, depending on the circumstance? Let's say if you had as he was pointing out, like in the Upper East, there are a lot of hedges, big hedges, and you were going to do something and you had a big hedge, but that would require you to shave your front hedge to 3 feet, whereas everybody else's is 11 feet, and they think, God, this is going to look terrible on our block. That seems to me to be would be worthy of consideration.
Mr. Hodgkiss, you're going to find out in about just a minute or two that why we put this off. This becomes really a very complex issue to try to resolve, and we've actually held off on jumping into it because it will be really consumptive of our staff time and us trying to wrestle these exact issues that you're bringing to the ground. Neighborhood compatibility being probably one of several issues that can really raise concerns, and then of course if you had a minority in a neighborhood who was felt that they needed to hold it to the standard that the city has, how do you resolve that? So not to interrupt getting a response from staff, but I just want to say this is that cracks open that Pandora's box of a million things around this issue.
Well, but it may be worth cracking open here. At least I want to discuss it.
Yes, I'm not to thwart you, but
Just to complete and make sure that I answer completely
Right.
your question about could the decision maker consider allowing an overheight hedge to remain on a property if they
Right.
found it compatible with the neighborhood. That could be an additional modification request they could seek from the staff hearing officer.
Okay.
And we do get those requests from time to time, and the decision maker would take all that into consideration.
Or it is an option right now.
It is an option if someone wants to keep an overheight hedge to request a modification to do that.
Okay, thank
Chair.
you very much.
I'm
Yes, Ms.
concerned
Weiss, if you
that
can help.
perhaps we're not fully addressing what the proposal is that if a neighbor, if a property owner is approached regarding a hedge enforcement issue and they just come to the staff with a bunch of letters and information saying my neighborhood's okay with that, I think what is being asked to consider is we just drop the enforcement case. That's quite different than what Ms. Brooke is explaining, is that if in the course of a development application someone wants to make a case for their hedge, including their neighbor's support, that's quite typical. And I want you to know that when we discover an overheight hedge where someone wanted to do an expanded living room into a setback, and we go to the site and we see the overheight hedge, we explain to them that you would need to cut down this hedge to 3.5 feet or whatever, or you could seek a modification. And so people do that now. But my understanding of this idea that we would consider input in our enforcement process, I think, is the nature of what Mr. Wiley was talking about. It's really not appropriate. Once we've determined that there's a violation of the code, it isn't a popularity issue of how many people in the neighborhood support you having your overheight hedge. So I'm definitely concerned about what might be implied by this proposal from the community. Thanks.
Okay, and Mr. Wiley wants to say something. And Mr. Bartolini, I think we will just hold off on more public comment just for right now, as while we wrestle this to the ground for today.
Mr. Chair, Mr. Casey advised me that maybe I miscommunicated or we miscommunicated. If the question was, could the Ordinance Committee recommend including bamboo in the suspension? If you were to do that, this lawsuit that we have on the Mesa would go away. You get to Superior Court trial, the judge is going to say, what's the current state of your ordinance? The past doesn't matter. In municipal code enforcement, the only thing that matters is what your municipal code says on the day of the trial. Oh. So if we were to suspend it, then that lawsuit would go away. I honestly, we do these things on a complaint basis, but in this case, I got to say, these neighbors got a legitimate complaint. And there was a process to deal with any privacy issues, and including potentially appeal to the city council often. And we have been vigorously pursuing this code enforcement complaint because this is not just a few feet over the hedge height. This is quite a few.
And if the city, Mr. Wiley, if the city were not, thank you for the clarification, by the way, because I understood it differently from your previous comments. If the city were not involved in a case like this, not just this case, but any case, what remedies would one neighbor have with regards to another in dealing with an issue of views or privacy? What's the avenue for them to deal with those things?
That's a good question. The city's view dispute mechanism is one. That's this private right of action. Potentially, it starts with basically contacting your neighbor and saying, can we work this out because your hedge or your trees are now blocking a view that I used to have, and I'll even pay to trim your trees, there's a term for thinning the trees out. That's where it starts. It could go to mediation. If that doesn't resolve it, it could go to arbitration. And we've even had a few disputes go to Superior Court and been resolved by a Superior Court judge. So that's one thing that happens. That's quite a thing to ask of a neighbor. And some neighbors have the wherewithal to do that, and they care that much about their views. Another way is a private right of action based on what's called a spite fence. And it doesn't have to actually be a fence. A hedge can be defined as a spite fence, and that's a violation of the California Civil Code. Has nothing to do with the city. And a spite fence is fairly well defined in law, such that there are circumstances where a judge can say, I know what you're doing here, and it's not because you wanted that fence, and it's not because of your privacy, it's because you're arguing with your neighbor, and you put that thing up there, and I'm going to order you to take it, to lower it down. And in that sense, a municipal code standard of 8 feet, for example, is very influential to a judge when someone argues that something's a spite fence. But again, that's a private right of action. And it's just, I think what I see is this delicate balance of when does the city, and in fact the city attorney's office, kind of go to court for you because it's gotten bigger than one neighbor's concerns versus another neighbor's concerns.
Right. It becomes a challenge, if you will, to the standard the city has.
Right, and it becomes a challenge to what the city council, maybe it was in 1957 or maybe it's in 2011, what the city council said is kind of our community standard, in this case for hedges.
And is there anything in the recommendation from staff today that would change our standards?
Well, all we've done in the past, all we're talking about today is suspending the enforcement.
Okay.
We haven't changed the standard, we're just not enforcing them right now.
Okay, thank you very much.
Yeah.
Okay, good. So we should be about ready for a motion here pretty soon. Yes, Mr. Hotchkiss?
I was going to make the motion if I could, and with a suggestion I wanted to ask the city attorney's office. If we made it part of this as a complaint driven as it is, and also stipulated that the complainant also had their property inspected so that what was good was for the goose was good for the gander, is that a problem in any way legally?
Mr. Vincent?
Well, Mr. Chair, the problem I see with inspecting the other properties that we have, at that point we have no evidence that there's actually a violation necessarily on that property.
Well, on either property, we really have no evidence. We just have a complaint.
We have a complaint that is arguably the complaining party is making a complaint of a zoning violation. That gives us a reasonable suspicion to believe that that violation occurs, and it's at that point, the staff is investigating that violation. The converse is not necessarily present simply because someone makes a call about a complaint.
Well, clearly the intent of this is to discourage spite between neighbors, and that could have that dampening effect.
We're fortunate to have both of our top attorneys here today. Mr. Weil.
I wanted to add, and I've been doing code enforcement for over 30 years. I have yet to see, people who live in glass houses shouldn't throw stones. So if you're going to go to the city and fill out a complaint, you shouldn't have a glass house. And I would say 9 times out of 10, we get a complaint from one neighbor, they'll come back and they'll say, oh, my neighbor, but he or she is doing this. And you know what our answer is? You know what? Fill out the complaint form and we'll pursue it. Because we try to be objective. And if you fill out a complaint form, we'll figure out if it's valid. And it might be tit for tat, but we often see neighbors turning each other in over this sort of thing.
Okay, well, I was trying to save a little staff time, but I think you just blew that out of the water. Thank you.
So I'm willing to entertain a motion if either one of you wants to step in here. Mr. Rouse?
Thank you, Mr. Chair. I would move to accept the staff recommendations as noted.
Second.
Okay, and it doesn't sound like I'm prevailing on either of you to eliminate bamboo from the staff recommendation for...
Right, and particularly because I think the enforcement issue is important here, and I don't want to gut that.
Got it. Okay.
Well, Mr. Chair, if I may, I think that given staff's experience and given the tools that they need to do to go out and do this kind of job, we need a little bit of the kind of latitude that we're going to provide them with here today to deal with these things on a case-to-case basis. So
okay.
I think it's the way to go.
Okay, very good. I won't be supporting the motion, but only because of that one piece. I support the general principle, and we'll see what happens when it comes to council. Unless there's any other discussion, all those in favor say aye.
Aye.
Opposed? No. Okay. Thank you very much. Do we have any other business today, Ms. Peterson? I think that's it, right? Okay, then we stand adjourned. Thank you very much.